Welcome to Let's Get to Work, Reimagining Disability Inclusive Employment Policy, brought to you by the Burton Blatt Institute at Syracuse University. And now, here's your host, Michael Morris.
My name is Michael Morris, and I welcome you to another episode of our podcast series, Let's Get to Work, Reimagining Disability Inclusive Employment Policy, part of the Research and Training Center funded by National Institute on Disability, Independent Living, and Rehabilitation Research, or we kindly refer to it as NIDLR. And I am so excited today to have a special guest with us, Chai Feldblum. Chai is a long-term civil rights advocate and scholar. She played a leading role in drafting, negotiating the Americans with Disabilities Act and later the ADA amendments of 2008. She has been a commissioner at the Equal Employment Opportunity Commission, EEOC. She helped advance employment civil rights, including people with disabilities, LGBTQ people, and women. And now, as a private citizen, she serves as vice chair of the AbilityOne Commission. For those of you not familiar with it, it is a federal agency devoted to the employment of people who are blind or have significant disabilities. So, an amazing, wonderful career. You have led our articulation of advancing economic justice for individuals with disabilities. I want to start right in with a basic question, and that is, how has your life experience shaped your vision and your work that has helped so many thousands and millions of people with disabilities?
Well, I am thrilled to be here, Michael, and I imagine anyone listening to the podcast already knows about you, but I just want to say I so appreciate the work you and your colleagues have done in research and analysis, because we need that combination, right, of people working in policy, people working in research, and as you just said, making sure to bring in the lived experience, the lived experiences of people with disabilities. There's a reason we have as our motto, nothing about us without us. Right, because that is so essential in terms of respect, So in terms of my personal experience, I am a lawyer, and I clerked for Justice Blackmun in 1986, 34 years ago. And that was my first introduction to disability rights, because the court was deciding a case about the scope of a provision of law called Section 504 of the Rehabilitation Act. And that was a section put in by Congress in 1973. It said any entity that got federal financial assistance could not discriminate against people with disabilities. And that was very important in terms of employment, as well as receipt of services. And they were hearing the court was hearing an employment case dealing with a teacher with tuberculosis who was not hired back even after she recovered from the tuberculosis. There was all stuff about fear of contagiousness, and therefore you don't have to hire people with contagious diseases. And so remember, this is 1986. This is the height of the AIDS epidemic. As a lesbian, I had many gay male friends who were dying of AIDS. And that law was important, Section 504 of the Rehabilitation Act, for at least providing some employment protection. So I got to know about this law as a clerk to Justice Blackmun. But then I left and I went to work for the AIDS project of the ACLU, really fighting for non-discrimination protection. That project had the concept of just for people with AIDS, but I and others realized that as an ethical matter, really as an ethical and strategic matter, we needed something broader. And that became the Americans with Disabilities Act, which again, the disability community had been working on that concept for some time. And to be honest, in terms of my career, I feel so lucky to have had the opportunity to do what I've done, as well as to work with some amazing, amazing colleagues in this fight. So, I became basically the lawyer who led the legal team in drafting and negotiating the ADA. And then, as you said, the ADA Amendments Act in 2008. And personally, I was diagnosed with anxiety disorder some 35 years ago. Very lucky in terms of having medication. I have not personally experienced discrimination, and that's because I was lucky about the jobs I held. I was a law professor for 18 years at Georgetown Law School. The anxiety disorder was not impeding my ability to do the job, and I could come out about having anxiety disorder. Same thing as an EEOC commissioner, etc. But there are a lot of people who don't have jobs where they feel safe to come out about their hidden disabilities. And that's why I have always felt that it is so important for me to come out, reduce stigma, whether that was coming out as a lesbian 35 years ago or coming out as a person with a hidden disability. And by the way, for your listeners, if you hear a dog in the background, that's Skipper, and Skipper is very supportive of disability rights. So if you hear him barking, it is because he's saying amen.
All right. We'll keep Skipper in mind as he chooses to join the conversation. So I appreciate so much you giving that background. It helps shape it certainly helps shape your views and articulate from your ability as a lawyer to really frame out legislation that, as you mentioned with the ADA, judges are appointed, and we have seen shifts most recently in judicial opinion. Has the ADA, and of course it was the reason for the amendments in 2008, has the ADA really withstood the test of time? And what direction do you feel we need to really focus on in terms of better protect individuals with disabilities from employment discrimination?
Well, the ADA was significantly restricted by the courts in the decade or so after it was enacted. I once participated in a panel called Honey, They Shrunk My Law, which is sort of how it felt. And the truth is, it got off on the wrong footing because of some of the ways in which the EEOC, the Equal Employment Opportunity Commission, that I later joined, wrote their regulations, right? Laws developed in three ways. It's what Congress passes, federal law, what Congress passes in terms of the text, what an agency that has responsibility for implementation says in its regulations and its, cases, and it decides, and then how the courts decide. Okay, that's what shapes a law. So some of the stuff that the EEOC put in its regulations in further defining the definition of disability in the ADA, which is physical, mental impairment that substantially limits a major life activity, right? That was put in, same language as Section 504 regulations, which had been interpreted broadly. And then you had courts that just dug into the language. Like they said, oh, substantially limits, that's a very high standard. Oh, if you're taking medication that now you don't have limitations, you're not a person with a disability. It was just, or one court, someone had a heart attack. He comes back to work and he's suddenly getting less work. He's a salesperson. And the judge actually says, well, I had a heart attack. That's not a disability, right? It's the assumption of the us and them. The them are the people who use wheelchairs or who are blind or deaf, as opposed to people with a whole other range of medical conditions that in fact generate discrimination. So we used to say you can be disabled enough to be discriminated against, but not enough to bring a case under the ADA. So it was very important to amend the ADA in 2008, which was really the first time we could do it. The cases had gotten bad enough and the political stars had finally aligned sufficiently that we had a chance of success in Congress. And while we needed to keep the language the same for negotiation purposes, we were able to define it more clearly as very broad, just very broad in terms of a definition of disability. So that helped in terms of starting enforcement. But the bottom line is an anti-discrimination law, whether it's disability or race or gender, will always be inherently limited in changing real economic outcomes because of the nature of an anti-discrimination law. You have to prove that you weren't hired because of your disability. Now, how many times do you think a hiring manager is going to say, oh, you're really good, but you use a wheelchair? Or, I don't know, you talked about how you have anxiety disorder. We just don't want to deal with that. People don't say that. So it's very hard to prove discrimination. So it's not about changing the anti-discrimination provision of the ADA, which I think is now very strong. It's understanding the inherent limitations of an anti-discrimination law and realizing that you need to pass additional laws that don't depend just on anti-discrimination to ensure that people get jobs and can have economic self-sufficiency.
Just wonderful points made is particularly how do we change a law? Do we change a law? Timing is everything. 2008, the stars align. I would say in 2022, the stars are not aligned particularly well. In terms of your work at EEOC, what actions taken by EEOC stand out for you in further articulating and advancing protections in the life cycle of employment for individuals with disabilities? So we move to a regulatory agency that really its actions had significant impact on employment of people with disabilities.
Yes, exactly. And you know what, before I answer that, I want to pick up on your comment of 2022 doesn't seem very, sort of optimistic about change. To me, it's about really understanding the landscape and then figuring out what can you do given the landscape, right? So I have always described myself as an optimist. It's the way I've been able to do this legislative and policy work, right, for 35 years. An optimist is not someone who just thinks, oh, everything's going to work out fine. My perspective, an optimist is someone who gets a good assessment of the realities on the ground and then says, okay, how can we move forward? How can we move a belief that one can move forward, taking into account the realities? And so for me, a lot of the work really needs to be done by regulation and by public-private partnerships, of which a lot can be done, and to leverage that. Okay, and I think as you and I continue to talk, Michael, some of that will be clear. And in fact, your question about EEOC is a great example of that. It's not like we passed a lot of laws during the 9 years that I was at the EEOC. I was appointed by President Obama. I served 2 terms. It's that the agency exercised the power it had to issue regulations that it had not exercised before. And it was a huge priority for me when I was there, specifically to increase jobs for people with disabilities, particularly significant disabilities, to get the EEOC to issue regulations for the first time since 1973, when, as I mentioned, Congress had enacted Section 504 of the Rehabilitation Act of 1973, which applied to private entities that got federal funding. But also Section 501 of that act said that federal agencies had to take affirmative actions to employ and promote people with disabilities. So now think about levels of law, right? Anti-discrimination law, that's a foundation. That's a foundation. But what can you do next to build on that? Well, what you can say is not only you can't discriminate, but you should take affirmative efforts, outreach efforts, recruitment efforts, affirmative efforts to hire people with disabilities. Like that's a plus. And that's what that law said, but it hadn't really been strongly implemented. And that law includes a non-discrimination component, Section 501, and this affirmative action. So when I was at the EEOC, the agency issued regulations for federal agencies saying you need to have targets of employment. Okay, you need to have goals. Goals are just goals. They're not, quotas, right? But goals focus the mind. And you need to have a goal of 12% of your workforce should be people with disabilities as defined broadly under the ADA. And 2% of that 12% should be people with targeted disabilities. And we had a list of like 10 targeted disabilities. And it included things like people who use wheelchairs, are blind, are deaf, have severe psychiatric disabilities, right? That might have forced them into an institution for some period of time. The idea is that even though the point of the ADA Amendments Act of 2008 was to make it clear that there's a spectrum of disability and we are all one community, it doesn't mean that people with different disabilities face the same level of discrimination, right? Someone who has depression, anxiety disorder, diabetes, cancer, any number of things that are protected as a disability can still get in the front door of employment because they're hidden. So we need to make extra affirmative efforts for people with more manifest and significant disabilities because they face greater employment discrimination. So that EEOC regulation of Section 501 has in fact changed hiring practices at federal agencies. Even though there's not really much of a hammer, there's still the goals. And then the EEOC continued every year I was there and since to bring individual cases of stopping disability discrimination. And often, their cases about not getting reasonable accommodations or firings, because it's very hard to prove a hiring discrimination case. But the EEOC as the enforcement agency has made a difference. And I know people sometimes wonder, well, have the claims changed over time? And I have to say, unfortunately not. There's still like almost the largest number of claims at the EEOC. And there's still, denial of reasonable accommodation, unfair discharge. And the EEOC tries to do the best it can with regard to decisions.
Again, I think about some of the differences between people who have apparent disability, they're blind, they're deaf, they're using some type of mobility system. But you've talked about both personal experience. We know people with the not visible disabilities are even less likely, even though advances have been made, to want to self-identify. And as a result, there are detractors of what the ADA has achieved, claiming, well, look, the numbers have not gone up. The ADA has not been successful. How do you answer those critics, and what is the approach? More can be done around creating a culture where people feel comfortable to self-identify with disabilities that are not apparent because they're not visible.
That the research shows that the employment rate, it just says employment rate for people with disabilities has not increased after the ADA in any significant way. Well, where does this data come from? It comes from data that based on a definition of disability that the Census Bureau, the American Community Survey, uses. When you look at those 6 categories, they all fit into what we would call targeted disabilities, as opposed to definition of disability generally, okay? people who are blind, people who are deaf, people who have difficulty caring for themselves, people with mobility impairments, okay? And it is true that that employment data, that has not moved up. And you know why? I believe, for the very first thing I said, these folks are never even given a chance at employment. Okay? We don't have data on whether the employment rate for people with diabetes and epilepsy and anxiety disorder and depression, we don't have data on whether that employment rate has increased. But I will tell you, the fact that the ADA stopped employers from being able to give you a medical questionnaire that you had to fill out before you applied, I bet you that there were people with epilepsy and cancer and, you know, other neurological diseases that got weeded out, you know? And now you can still give someone a medical questionnaire after you've given them a conditional job offer. So then if you say, oh, hey, no, you really can't have this job because you have diabetes, the employer has to prove how that's connected to the job. Okay, so I actually think that there are people who are getting hired because of the ADA who would not have gotten hired before. I believe there are people who, if they were ready on the job, or they had a hidden disability that they didn't have to disclose before, who then needed an accommodation to stay on the job. I think they probably are staying in their jobs for all the employers that have voluntarily complied. And that's not going to get captured in the statistics because we don't yet have, and I believe we should on a national level, a survey of disability that is way beyond, you know, that ACS, that American Community Survey, 6 categories survey, right? So number one, I do think there has been probably advances, but the most important is the change in attitudes, you know, the change in attitudes that someone with depression or anxiety disorder or PTSD, bipolar, right, on the psychiatric, or people with significant health conditions, that they can do the job, you know, and the only way that works is for people to come out. I mean, it's what we discovered in the LGBTQ community. You had to come out in order to reduce stigma and in order to change people's minds. And that's what people with disabilities, with hidden disabilities, need to do. But I completely understand anyone who's afraid of doing that. And so you come out when you can. But still, people who are blind, deaf, use a wheelchair as a little person, they don't get a choice about whether to pass. So we have to change the employment picture for those folks.
Thank you. Let's switch to your newer role as Vice Chair of the AbilityOne Commission. Some of our listeners are probably never heard of AbilityOne. Maybe you can describe a little bit about the goals of the AbilityOne program and really what has been a significant change that recently took place based on your leadership and others with the commission. And what's the impact of all this?
Yep. So, you know, when I said we need additional laws, I see what AbilityOne program is trying to do, sort of the third leg of the stool that I described. You know, the first leg is anti-discrimination, foundation. Second leg is a law, let's say, that requires affirmative action, which is what Section 501 does for federal agencies, as I described. And Section 503 of that same 1973 law said that anyone who has a contract with the federal government, anyone who has a contract, has to engage in affirmative action for people with disabilities. Again, there had been no regulations on that until the Obama administration. And under the leadership of Pat Shue and others, they were the first agency prior to the EEOC to say to federal contractors, you need to have goals. Now, a major flaw in that regulation, which I said at the time and I continue to say now, is that they created a 7% target, but that was for people with disabilities as defined under the ADA. Incredibly broad. A lot of federal contractors can meet that goal by just encouraging people with hidden disabilities already on the job to self-identify and self-identify anonymously. Now, I think that's helpful, but it's not the same as a goal for targeted disability. But even assuming that the Department of Labor changed that, did what we did at EEOC, 2% goal for people with targeted manifest disabilities, there's still a limitation in enforcement. Technically, under the law, you could pull back someone's contract if they haven't met, let's say Section 503 requirements. Is that going to happen? It's not going to happen. But it does mean it does something. It's a second leg of the stool. It gives a hiring manager who sees a person who uses a wheelchair and a person who doesn't, who are applying. And the person who uses a wheelchair is just as qualified. Now there's a plus. You have to just make a choice. They're both equally qualified. You have an affirmative action goal in mind, that hiring manager gets a plus for hiring the person who uses a wheelchair. That's good. So, okay, second leg of the stool. What's the third leg of the stool? The third leg of the stool, in my mind, is to leverage money. Leverage money. I call it capitalizing on capitalism, okay? Make it financially worthwhile for someone to hire people with disabilities. Now, the AbilityOne program has the potential to be that third leg of the stool. It's officially a third leg of the stool right now, but for anyone who does know about AbilityOne, it just seems like a really bad leg. And I had heard of AbilityOne, but I didn't really know about it until I was on the President Biden's transition team and I was given the job of reviewing the agency. I dug into its entire history, what it does, including a report from the National Council on Disability that recommended that the program be completely dismantled, phased out, because from their perspective, the program itself was so flawed. Okay, so what's the program? What are the flaws and how are we fixing them? So the program leverages the power of federal procurement. Okay, it says the commission has the authority to set certain contracts on a list where those contracts have to go to nonprofit agencies that have to hire at least in their direct, the hours worked on the contract, 75% people with disabilities. And that's a minimum. They can have a setting with 100% blind people or 100% people with intellectual disabilities. Not at all a setting of integration that we would see as important for how people with disabilities work in our economy. So how did that happen? Right now, there's like $4 billion in contracts that go through this program, 40,000 employees. It started in 1938, and it was set up just for blind employees. So what they assumed in 1938 was that blind individuals could never get jobs in the general economy. It would not happen. And let me tell you, talk about rampant discrimination at the time. It would not happen. So the only way they could get jobs if they got certain federal contracts limited to just entities that were hiring blind people. Now, again, the assumption of what blind people could do was very low, right? The expectations, it was basically doing brooms and mops, right? And then in 1972, they extended that to people with significant disabilities, which they defined as a disability that made you unable to work in the normal competitive economy. Okay, so the whole assumption was that people couldn't work, and that's why they needed these dedicated contracts. What we have done over the past year at the AbilityOne Commission is work on and issue a new strategic plan that changes the assumptions, that says people can work. What you need to do in return for getting this almost like dedicated contract, you have to make sure you're doing job customization for people who are coming in. Is it the right job? Do they have the right supports? You need to have a person-centered employment plan for them. Where do they want to go in their career? You should be having partnerships with for-profit companies where people can move to those companies if they want to. We are not in this strategic plan wanting to take away any job from anyone currently in a job who wants that job. But we don't want to do that. But there are a lot of people who don't want to just stay in that nonprofit. They'd like to move to Google or wherever. So a lot of work. I mean, this is a 5-year strategic plan. I have, I think, a 5-year term. So we'll do a podcast 2.5 years from now, Michael, and then 5 years from now, and we will see whether the AbilityOne program has become a conduit for people working in the general economy, because there's nothing like having a job where the employer has to hire a certain percentage, not 75%. I mean, you're not going to work with that in integration, but has to hire a certain percentage. I mean, that's so much better than an anti-discrimination law, right? But it has to be a good program. Has to be a good program.
I know you mentioned that the National Council said it's almost, this is not what they said, but I'm paraphrasing, it's so broken, just end the program. But does that make sense when you think about it? And I take your figure, $4 billion in government procurement. Can't we restructure it in a way that there would be absolute benefit to economic advancement for people with disabilities?
I absolutely believe there's a way to do that. And that's why I decided to join the commission to see if we could make that possible. And here's how. If you look at the National Council on Disability report, and I have that practically on a whiteboard, every single one of their findings, which I thought were very important. And can we do check, check, check in terms of fixing things? Okay. Almost all of their findings were based on structural problems within the commission, whether it was financial, whether it was the role of the central nonprofits. I mean, a lot of structural issues that have either already been fixed under I'll tell you, we have a new executive director, Kim Zeik, who just became the actual executive director, formally a month or so ago, but has been there since I've been there. And George Govan, our financial person. I mean, a lot of things have been fixed already. But what the report said after listing all of that is, and you know what, bottom line, philosophically, it just has to go, because it's based on the assumption that people cannot work in the general competitive economy. And their solution was, you phase out the program over 8 years, and Congress passes a law that makes those Section 503 goals mandatory. Now, when I read the report, I thought, this is an agency that needs some help, needs an infusion, But this solution of having Congress pass that mandate, that quota mandate, that's not happening. I don't see it. Back to the question of politically what's possible, right? I don't see it possible happening. And even if it did, what sort of enforcement would it be? So I felt you would dismantle a program that has great leverage through leveraging federal procurement and not really replacing it with something realistic. So instead, let's modernize the program so that, number one, the contracts that are coming should be contracts for not just, manufacturing, production services, although those can be very good jobs, if you set them up that way, but also computer jobs and tech jobs and health jobs. Right now, about 30% of the jobs are in those types of jobs, those types of more high skilled, but let's get more and more of them. So I think you've got to get more types of jobs that fit into the economy. You have to create an incentive for the nonprofits to help folks move if they want into other jobs, because if they move, then they open up a seat for someone else who otherwise won't get a job. So you structure it that way. And then for integration purposes, you have to deal with this mandatory 75% ratio.
Right.
And you can do that in two ways. Congress can change it, and I think they should. And, but that can be a long process. And I think on the short term, Congress should at least give the AbilityOne Commission the authority to do pilot projects. Let's do pilot projects where it's less than 75%. And so let's say it's 50% in a contract, and then you get other people without disabilities who have done work in that area, so you can show past performance, capacity. You train up the folks, and then you get another contract. So you're not ultimately losing job slots by lowering the ratio, if you also use it to get more contracts. So that's the long-term vision. That's the long-term vision.
Right. Now, you didn't mention that one of the things the commission did was end the use of 14C. What's the significance
Yeah.
of that for our listeners?
Yes, thank you. That was probably the two things I spent the most time on this past year, ending the 14C through the regulation and then the strategic plan. So one of the National Council on Disabilities complaints, legitimate concerns, was that under the Fair Labor Standards Act, if a person with a disability can't, quote unquote, produce at the same rate of people without disabilities doing the same job, you can pay them less than the federal minimum wage. That meant, number one, that people with disabilities were subject to these productivity tests each year that were just sort of disgusting. You know, their colleagues without disabilities didn't have to, and they got paid less than the federal minimum wage. And early on, the AbilityOne contracts were workplaces, a lot of employees were being paid less than the minimum wage. And by the time I came onto the commission a year ago, that had already started to go down significantly, but it still was permitted. And I think the outward perception was that many AbilityOne employees were being paid less than the minimum wage. So it made a difference to issue a regulation that absolutely simply prohibited a nonprofit who was going to get a federal contract of sometimes millions of dollars to pay any of their employees less than the federal minimum wage, or less than the prevailing wage if otherwise required on the contract. Now, by the time we issued the rule, we estimated there were only 1,200 employees on service contracts that were getting paid less than the federal minimum wage. So a small sort of absolute number out of 40,000 employees, and about 800 employees might have not been getting the prevailing wage. So our rule didn't necessarily, quote unquote, impact a lot of people, although for those 1,200 people, that is a huge difference. We gave the nonprofits only 3 months to come into compliance. The disability community comments on the reg asked us to give anywhere from 1 to 2 to 4 years for people to come into compliance because they were afraid that people might be just kicked out of their job. We gave them 3 months, and we allowed them to ask for an extension for a year. And you know what? A few, but not many NPAs have asked for an extension. We'll be monitoring them, but somehow they all managed, and we will be trying to see if we can find out how they managed to get rid of 14C. And this is about valuing people for their work. That's what it's about. It's about economic self-sufficiency. So they actually have money and they're being valued. And so that was a huge, huge milestone for the AbilityOne program to simply disengage from that, even above and apart from the folks. And actually, if people are interested, if you go on the AbilityOne website, soon we will have the video of the public meeting that we had in, like October 25th, shortly after the effective date of October 19th. And we celebrated the end of 14C by having a panel of employees who had been paid some minimum wage at some point and then got paid actual real wages, talk about their life experience. That's a panel worth watching.
That sounds wonderful. I know we're running out of time, but let me try to maybe some quick kind of thoughts from you. And these are not questions that can be answered quickly, but we're all following the aftermath of the Dobbs decision, eliminating Roe v. Wade, constitutional right to abortion, turning it over to the states. What's the implication for women with disabilities, and what may be the impact on employment, and really the impact on women with and without disabilities?
Yeah, well, one thing is that once you have these restrictions on abortion, I mean, even in states that might allow you to get an abortion for some medical reason, doctors are just going to be scared. And so, there's just going to be limitations on abortion that will affect women with disabilities. even if under the state law, theoretically, they should be able to get the abortion. And I think it's also part and parcel of a lack of respect for people's bodies and people's choices. And when you think about what we need to do, we need to change societal attitudes about people with disabilities and getting rid of Roe versus Wade, getting rid of that commitment to personal autonomy under the Constitution and leaving it to the states. That is going in the wrong direction.
Okay. And two other quick questions is the research center with the researchers at Syracuse, Rutgers, and Harvard are studying disability inclusive employment policy. I think your answer related to 14C is very relevant, and you've answered this. But as maybe I'll combine it with a final question, which is to say, how do we reframe and define disability justice in the employment sphere over the next 5 years? What will be your focus, and what are the battlegrounds that you will be striving to really take part in?
Well, the first part of your question and this one, absolutely Mish. I mean, let's think, what does disability inclusive employment policy actually look like? Okay, so that looks like, from my perspective, three things. It's changing the attitude of what type of jobs people with disabilities are capable of, so they get hired. Two, it changed the assumptions of their coworkers about what they are capable of. So it's inclusion within their colleagues. That's why integration is so important. And finally, it's getting the tools and job supports to make sure that they can succeed. It's not enough to get hired. It's not enough to be quote unquote accepted if you're not given the accommodations and the devices to succeed, right? So we could say, oh, we want some blind individuals working on AbilityOne contracts to be able to work for a for-profit, right? Well, that's great if you can sort of help with the placements, which we hope the AbilityOne nonprofits can do. But what if the person doesn't have the type of technology they need to be successful? How does that help that person? A disability inclusive employment policy means that employers need to understand how to themselves do job customization, themselves have those devices and accommodations. So my goals over the next 5 years, it is, I would say, three things. It's making the AbilityOne an incredibly strong leg of that stool in exactly these ways. And the nonprofits are not only helping to move their folks out, the nonprofits are educating the private employers about what they need to do. Two, it's continued changes in attitudes and expectations of capacity. We still have a long way to go. And the third one, and this really just came to me yesterday because I heard, a person say, well, I just focus on ability, not disability, or I don't even see the disability. And I'm like, that's like people who say, I don't see race, I don't see color. If you say that, to me, that means you're not seeing the person. It's, what do you mean you don't see the disability? The disability is part of that person's lived experience. You should see the disability is not the only thing about that person, but it's part of that person. And how are you going to do reasonable accommodations, et cetera, if you say, I don't see the disability? So I will tell you, maybe this will continue to be called the AbilityOne Commission, but, that was they did this change, 15 years ago. And I think it was definitely well-meaning, but in the disability community, we don't say ability, we say disability, because there's nothing wrong with having a disability. And you have, of course, abilities. So I would like people to have disability pride. Have disability pride. See the disability and see how much that person can do.
I thank you so much for your sharing your vision, your values, your work with us. Most of all, we appreciate your leadership. Thank you for this conversation today. Look forward to continuing to follow the advocacy that you bring forward.
Thank you. And I look forward to having us partner and leverage the research and leverage the work. Michael, it's been a delight.
You've been listening to Let's Get to Work, Reimagining Disability Inclusive Employment Policy, brought to you by the Burton Blatt Institute at Syracuse University. Don't forget to subscribe to the podcast at Apple Podcasts, Google Podcasts, or wherever you listen to podcasts.